Gift Oruka, Cynthia Ifoma Edu, Ote Achi, Nike Lawrence, Onyinyeche Owoke, Aguma Prince Otuna, Faith Osila, Faith Fobi, Wipe V. Gozier Johnson, Godfrey Prince Chidi, Amadi Goodness Chiamaka, and Miss Fubara Ijoma Felix, and Emoa Local Government Council, the chairman, Emoa Local Government Council, and River State Local Government Service Commission. My lord, that is all I'm saying.
Yes, who are the council?
May I please the court? My name is KIC Chukwezie. My lord, I appear for the claimants. Most grateful, my lord.
KIC Chukwezie.
Yes, my lord, for the claimants.
Sorry. Yes.
With due respect, my lord, O.F. Emiri, I appear for the first and the second defendant. Appearing with me are Ohajua and Winston Churchill Madume. Appearances for first and second defendant, my lord.
Let us see. Who are the counsel that are appearing with you?
Chioma Ohajua, my lord, and Winston Churchill Madume appear with me, my lord. Most grateful, my lord.
Thank you.
I do not know if the third defendant is represented, but
yes, my lord.
I know that they are aware. Oh, very well.
Yes, who appears for the third defendant?
Yes, with greatest respect, my lord, M.D. Moses. My lord, I appear for the third defendant. Yes, my lord, M.D. Moses.
Yes.
Bluetooth mode.
As this is the cost decision. The claimants commenced this suit by way of an originating summons filed on the 9th day of May 2022 and submitted the following questions for the determination of this honorable court. 1, whether or not the demotion/downgrade in the employment grade level, withholding, slashing down the salaries of the claimants by the defendants does not constitute disciplinary action. 2, whether having regard to section 7 sub 5 of the 4th schedule to the 1999 Constitution as amended, the first and second defendants are vested with the powers to downgrade/demote the employment grade level of the claimants, cut down or withhold their salary, the salary of such an employee, public officer, and more particularly the claimants. 3, whether having regard to section 44, sub 1, 48 sub 1 and 2 of the River State Local Government Law number 5 of 2018, the first and second defendants have any such power to impose any such discipline on the claimants, public officers, including the demotion/downgrading, withholding, or slashing of salary of such employees, particularly the claimants, without recourse to the recommendation of the third defendant. 4, whether having regard to section 36, subsection 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, the demotion/downgrade of employment grade level, withholding, cut down of salaries of the claimants by the defendants without any established allegation of misconduct, constitution of panel of investigation/inquiry thereto, with an opportunity to make representation afforded the claimants before any such panel is consistent with the principle of natural justice. 5, whether having regard to section 17 sub 3 A, B, C, and D of the 1999 Constitution of the Federal Republic of Nigeria, the demotion/downgrade, withholding, slashing of the claimant's salary is consistent with the claimant's right to adequate means of livelihood, equal pay for equal work without discrimination as guaranteed by law. The claimants therefore claim the following reliefs against the defendants, jointly and or severally. A declaration that first and second defendants, by reasoning of powers/function vested in them by Section 7 sub 5 of the 4th Schedule of the 1999 Constitution of the Federal Republic of Nigeria as amended, has no such power, right, authority whatsoever to demote, downgrade the employment grade level of the claimants, nor withhold, cut down, slash the monthly salary of the claimants. B, a declaration that by the provision of Section 44 sub 1, 48 sub 1 and 2 of the Rivers State Local Government Law number 5 of 2018, the first and second defendants have no such powers, right, authority, capacity whatsoever to impose any form of discipline with regards to or by way of demoting / downgrading the employment grade level, withholding, slashing, cutting down of the salary of the claimants. Hence, any such demotion, cutting down of the salary of the claimants, downgrade, withholding, slashing of the claimant's salary is a violation of Section 48 sub 1 of the Rivers State Local Government Law number 5 of 2018. C, a declaration that the demotion / downgrade of the employment grade level, withholding, reduction of salaries of the claimant without any indictment of any misconduct by any panel of inquiry / investigation convened by the appropriate authority with respect to any allegation in compliance with Section 43 sub 1 and sub 2B of the Rivers State Local Government Law number 5 of 2018, and non-observance of principle of natural justice is unjustifiable, therefore wrongful, unlawful, and a gross violation of the claimant's right to fair hearing as guaranteed by Section 54 sub 1, 2, and B of the Rivers State Local Government Law number 5 of 2018 and Section 36 sub 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended. D, a declaration that the demotion, downgrade in employment grade level, withholding, slashing of the salaries of the claimants, public officers by the defendants without due process of law is unjustifiable, wrongful, unlawful, illegal, and constitutes a violation of the claimant's right to adequate means of livelihood, equal pay for equal work, without discrimination as guaranteed by Section 17 sub 3 A, B, C, and D of the 1999 Constitution of the Federal Republic of Nigeria. E, an order of this honorable court on the defendants to, within 7 days of the judgment of this court, reinstate the claimants to their employment grade level before their unlawful demotion / downgrade by the defendants. F, an order of this honorable court on the defendants to, within 7 days of the judgment of this court, release in full the withheld and unpaid salaries of the claimants, whether those held in full or by way of deductions as applicable to any of the claimants' case whose salary is withheld in part or in full, and particularly those affected by the defendant's unlawful demotion / downgrade of employment grade level, now computed as follows. First claimant, 160,000 naira. Second claimant, 799,198 naira. Third claimant, 150,396 naira. Fourth claimant, 326,235 naira. Fifth claimant, 513,168 naira. Sixth claimant, 131,015 naira. Seventh claimant, 243,266 naira. Eighth claimant, 219,015 naira. Ninth claimant, 267,685 naira. 10th claimant, 458,395 naira. 11th claimant, 276,516 naira. 12th claimant, 267,516 naira. 13th claimant, 574,749 naira. 14th claimant, 146,022 naira. 15th claimant, 121,665 naira. 16th claimant, 504,941 naira. 17th claimant, 708,777 naira. 18th claimant, 451,200 naira. And 19th claimant, 275,726 naira. G, an order of this honorable court on the first and second defendants to, within 7 days of the judgment of this court, to publish a written apology in 2 national newspapers with circulation across Nigerian states to the employees of the first defendant, including the claimants who are affected by the defendant's unlawful employment, demotion, /downgrade, and withholding of salaries. H, and the order of this honorable court on the first and second defendants to pay each and every of the claimants so affected by the first and second defendants' policy of demotion, downgrade, withholding, salary cut, the sum of 1 million naira representing damages for trauma, inconvenience, displacement, embarrassment, and losses the action of the defendants have caused the claimants. And I, for such further order or orders as the court may deem fit to make in the circumstance. It is pertinent to note that the claimants filed a 43-paragraph affidavit in support of the originating summons deposed to by the first claimant on record on the 27th day of June 2022, which was however regularized on the 24th of July 2023. Annexed to the supporting affidavit are documents marked exhibits Solomon 1-12, Chioma 1-6, Harmony 1-4, Omoni 1-5, Evelyn 1-9, Chukunda 1-5, Ovunda 1-5, Isabella 1-5, Gift 1-4, Cynthia 1-9, Achineke 1-5, Onyeyechi 1-4, Aguma 1-6, Faith 1-3, Phoebe 1-3, Wikpe 1-9, Godfrey 1-5, Chiamaka 1-4, and Ijeoma 1-7. The learned counsel to the claimants also filed a written address wherein these 2 issues were submitted for the cost determination. 1, whether by sections 31, 32, 33, 34, 35, 36, 37, and 38 of the Rivers State Local Government Law number 5 of 2018, section 7 sub 5 of the 4th schedule to the 1999 Constitution as amended, which set out the power and function of the first and second defendants. The first and second defendants have such powers to demote, downgrade the claimant's employment grade level, and or withhold, cut down the claimant's salary. 2, whether by sections 44 sub 1, 48 sub 1, 54 sub 1 and 2 of the Rivers State Local Government Law number 5 of 2018, section 36 sub 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, the defendants can impose disciplinary action on the claimants, that is, demote, downgrade, withhold, or cut down the salaries of the claimants without according them fair hearing in line with principle of natural justice. The learned counsel to the claimants, KIC, Chukwueze Esquire, argued on issue 1 that sections 31, 32, 33, 34, 36, 37, and 38 of the Rivers State Local Government Law number 5 of 2018, as well as section 7 sub 5 of the 4th schedule to the 1999 Constitution, which set out the powers and functions of the first and second defendants, do not give them any power to demote or downgrade the claimant's employment grade level with the third defendant. The laws referred to do not also give the first and second defendants the power to withhold the salaries and or cut down the salaries of the claimants, that the first and second defendants acted ultra vires when they cut the salaries of the claimants. The court was out to resolve issue 1 in favor of the claimants. With respect to issue 2, the learned counsel to the claimants submitted that the first and second defendants do not have the powers to impose disciplinary action on the claimants without recourse to the third defendant, that the claimants must be accorded fair hearing, and any allegation of misconduct must be established before any disciplinary action can be meted on them, that the defendants failed to give the claimants any notice of wrongdoing, nor were they invited to any form of to make any representation to any authority in respect of any misconduct. the court was out to resolve issue 2 in favor of the claimants and enter judgment in their favor. Counsel also referred to section 36 sub 1 of the 1999 Constitution as amended, sections 48 and 54 sub 1, 2, and B of the Rivers State Local Government Law number 5 of 2018, as well as the case of Alhaji Yusuf G. Ali versus Mrs. Ramatu J. Ahmed. Citation is given. It is apposite to note that the claimants filed an additional written address on the 27th day of June 2022, which was regularized on the 24th of July 2023. The learned counsel to the claimants referred to the dictionary meaning of the word discipline and argued that discipline is akin to punishment, which is the act of inflicting a consequence or penalty on someone as a result of a wrongdoing or the consequence or penalty itself. That the Labor Act in sections 91, 7, 15, and 5.1 guarantee payment of wages to workers, that the claimants who are public officers in the service of the government of Rivers State need to be protected as their employments have statutory flavor. Counsel referred to the cases of Para State Judicial Service Commission and 3 others versus Mrs. Yetunde Zainab Tolani. Citation is given that the action of the defendants in refusing to pay the claimants their salaries or to even cut or reduce their salaries without giving them fair hearing did not follow due process of law. The cases of Otemolu versus Siu A.M. Makari and others, as well as Alhaji Wahab Ariji versus Mustafa Ariji, were also referred to. That while the role of the third defendant in the indictment and discipline of the claimants is indispensable, the third defendant, however, did not play any role before the salaries of the claimants were withheld or reduced. The court was finally urged to grant the reliefs in the suit. In opposition to the originating summons, the first and second defendants filed a counter affidavit of 77 paragraphs deposed to by Princess Werenda Anwuri Ohoji, the secretary in the law firm of Chidi Lloyd and Associates, together with a written address on the 28th day of July 2022, which were, however, regularized on the 8th day of June 2023. In the written address supporting the counter affidavit, the learned senior counsel for the first and second defendants, Professor O.F. Emery, SAN, proposed this loan issue for the cost determination. That is, considering that a master-employee relationship exists between the parties and the defendants gave all the claimants an opportunity to be verified and heard, can the claimants who refused or rejected the opportunity or are unqualified for their respective status be entitled to the relief sought in the originating summons? The learned senior counsel submitted by way of preliminary points that the instant suit was not properly initiated because the suit is not one for interpretation and application as provided in Order 3, Rule 1, Order 2, Order 3, Rule 1, and Rule 2, Sub 2A, and Rule 3 of the Rules of this Court 2017. That the word interpretation is the process of determining what something, especially the law or a legal document, means, referring to the Black's Law Dictionary 8th edition at page 2399. The court was urged to direct the claimants to comply with the proper mode of initiating the suit. Also motto, convert the process to one originated by complaint. It is noted that the learned SAN did not make any submission with respect to the substantive suit, as according to him, it is premature to do so until the preliminary issue relating to the mode of commencing the suit is determined by the court. The learned SAN for the first and second defendants further submitted by way of adumbration at the hearing of the suit on the 30th day of November 2023, that since the facts in the counter affidavit of the first and second defendants that the claimants abandoned their place of work have not been challenged by them, such facts are deemed admitted. An address of counsel cannot take the place of evidence. The court was urged to refuse the reliefs in the originating summons. The claimants filed a reply on points of law in response to the processes of the first and second defendants on the 6th day of September 2022, wherein the loan issue identified by the learned SIG for the first and second defendants was adopted and responded to. It was posited that since the first and second defendants did not make any argument in support of the sole issue nominated by them, the said issue is deemed to have been abandoned, and the court cannot argue their case for them. It was further submitted that paragraph 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, and 26 of the first and second defendants' counter affidavit should be discountenanced because they offend section 115 of the Evidence Act, that the informant to the deponent, not being an employee of the first and second defendants, has no personal knowledge of the facts supplied to the deponent, and he also failed to disclose the source of his information. It was further argued that the status of the relationship between the claimants and the defendants is one of employment with statutory flavor and not that of master-servant relationship, that the claimants are public officers in their own right, referring to the case of Oba J.A. Wolola versus the governor of Ekiti State. Citation is given. On the argument of Lenene S.A. for the first and second defendants that the suit was improperly commenced, it was implied that the suit relates to the interpretation of section 5 sub 1 of the Labor Act, section 36 sub 1 of the 1999 Constitution as amended, section 44 sub 1, 48 sub 1 and 2 of the Rivers State Local Government Law number 5 of 2018, and section 7 sub 5 of the fourth schedule to the 1999 Constitution as amended, all with respect to the powers of the first and second defendants to downgrade or demote them or reduce or withhold their salaries without hearing from them or recourse to the third defendant, that the suit was properly commenced via originating summons, referring to the cases of the government of Kano State versus Economic and Financial Crimes Commission and Central Bank of Nigeria and another versus Olatayo Aribo. Citations are court provided. According to the learned counsel to the claimants, since the affidavit in support of the originating summons is unchallenged and uncontradicted, the facts are deemed to have been admitted, referring to the case of Issa Shaibullah versus People's Democratic Party and 3 others. Citation is also given. The court was urged to grant the release in the originating summons, having assumed jurisdiction in the matter. Counsel referred to Standard Chartered Bank Nigeria Limited versus Adegbite. Citation is given on section 254C1 A, D, and G of the 1999 Constitution as amended. In opposition to the originating summons, the third defendant filed a counter affidavit of 18 paragraphs deposed to by Constance Amadi, the principal legal officer of the third defendant, together with a written address on the 28th day of July 2023. In the supporting written address, the learned counsel to the third defendant, Chief Temple Amadi, identified these 2 issues for the course determination. 1, whether this discloses reasonable course of action against the third defendant. 2, whether the claimants have satisfactorily proved their entitlement to the declaratory and monetary relief sought against the third defendant in the originating summons. The learned counsel to the third defendant submitted on the 2 issues which were argued together that the course of action is bundle of facts which the law recognizes as giving claimant a substantive right to make the claim for the remedy or relief being sought, that the court is enjoined to only consider the statement of claim or the affidavit as the case may be in order to ascertain whether reasonable course of action has been disclosed in the suit. Counsel referred to the cases of Oni versus Igbala Jobi, Hussaini versus Atta, and Attorney General Abia State against Attorney General of the Federation. Citations are all given. That the instant suit does not disclose any reasonable course of action against the third defendant. It was further argued that he who asserts must prove his assertion, and the burden of proof is on the claimant, referring to the case of Gusau versus Lawa. Citation is also given on sections 131 and 133 of the Evidence Act. That since reliefs A, B, C, and D are as endorsed in the originating summons are declaratory in nature, the claimants must succeed on the strength of their case and not on the weakness of the case of the third defendant. Counsel referred to Ugochukwu versus H River State, and Ndu versus Onudike Properties Limited. Citations are also given. It was further argued that since original summons is not appropriate where there are substantial disputes of facts, the reliefs in the suit cannot be granted without oral evidence. Counsel referred to Fakimi versus Bunas. Citation is also given. The court was asked to strike out the name of the third defendant from the suit for non-disclosure of reasonable cause of action or order for pleadings in line with Order 3, Rule 17 of the Rules of this Court, 2017. It is apposite to note that the learned counsel to the third defendant further argued by way of adumbration on the 30th day of November 2023 that since the claimants did not file any process to counter the facts in the third defendant's counter affidavit and the submissions of the third defendant, they are deemed to have admitted the facts. I have seen that the claimants did not file any further process or reply on points of law to the processes of the third defendant. Now, court's decision. It is apposite to note that the defendants filed notices of preliminary objection challenging the jurisdiction of this honorable court to entertain this suit, since the issue of jurisdiction is pivotal to any adjudication. Same shall be determined first before the determination of the substantive suit. See the case of First Bank of Nigeria Limited versus Dr. Kenneth Kenwogu. Citation is given where the Court of Appeal, Abubakar Sadiq Umar JCA, held as follows on the significance of the issue of jurisdiction at page 11, paragraph F of the report. And I quote, "It is tried that issue of jurisdiction is a threshold issue, and whenever issue of jurisdiction is raised, in whatever guise, the court must resolve the issue first." End of quote. See also Chief Ambrose Albert Uhuru and another versus the President versus President Muhammadu Buhari and others. Citation is also given. The notices of preliminary objection filed by the defendants shall be considered seriatim. The first notice of preliminary objection to be determined is the one filed by the learned senior counsel for the first and second defendants, Professor O.F. Emery S.A. The objection, which was filed on the 7th of August 2023, prays for the following release from the Honorable Court. 1. An order of the Honorable Court striking down the suit for being improperly commenced. 2. An order striking down the suit as it involves substantial disputes of facts that cannot be properly determined by originating summons. 3. Or on the alternative, an order for parties to file pleadings in this suit as facts are contentious and cannot be resolved by affidavit evidence. 4. And for such order or further orders as the Honorable Court may deem fit to make in the circumstances. The grounds for the objection are that the instance suit is not properly instituted as it contains facts that are controversially contentious and cannot be properly resolved via affidavit evidence, and that filing of pleadings will assist the court in determining the matter on its merit. In support of the objection is an affidavit of 4 paragraphs deposed to by Winston Churchill Madume, a legal practitioner in the law firm of Chidi Lloyd and Associates, the solicitors to the first and second defendants applicants. The learned SN also filed a written address wherein this loan issue is submitted for the court's determination, whether this action can be effectively determined by originating summons when issues of substantial disputes of facts are involved. It was submitted on the sole issue that by the provisions of Order 3, Rule 3 of the rules of this court, originating summons can only be used when what is in dispute is a mere construction or interpretation of document in respect of which pleadings are unnecessary, and not where conflicts of facts or substantial disputes of facts are involved. That since the claimants are contending that the demotion/downgrade of their employment grade level and the withholding/slashing of their salaries is unlawful, and to reinstate them to their alleged grade levels, the suit can only be determined through pleadings because there are disputable facts which cannot be properly resolved through originating summons or affidavit evidence. That this honorable court lacks jurisdiction to entertain the suit as presently constituted, the court was asked to resolve the loan issue in favor of the first and second defendants applicants and grant a notice of prior objection. References were made to the following cases: Government of Kogi State and others versus Oba Ese Mohammed, National Bank of Nigeria versus Lady A, Alakija, and another. Fashio Motors Limited versus UBA Limited. Standard Cleaning Services Company versus the Council of Obafemi Awolowo University, Ile-Ife, and Adetipe versus Theophilus. Citations are all given. In opposition to the notice of re-objection of the first and second defendants applicants, the claimants filed a 12-paragraph counter affidavit deposed to by Kingdom Chukwueze Esquire, a legal practitioner in the law firm of Des Attorneys, together with a written address on the 15th day of August 2023. The learned counsel to the claimants, KIC Chukwueze Esquire, submitted this sole issue for the court's determination, whether this suit within the circumstances of questions, issues of law raised for interpretation / construction of the court is properly commenced under the originating summons procedure. It was posited on the single issue that this suit is properly commenced pursuant to Order 3 of the Rules of this Court 2017, that the claims before the court clearly fall within the purview of Section 254C1 of the 1999 Constitution of the Federal Republic of Nigeria as amended. It was further argued that since the instant suit is for the interpretation or construction of Section 54 of the Rivers State Local Government Law Number 5 of 2018, with respect to the disciplinary powers of the defendants, there are no disputes of facts, and the suit was properly commenced by way of originating summons. The court was urged to refuse the application and assume jurisdiction in the matter. Counsel referred to the cases of Government of Kano State versus Economic and Financial Crimes Commission and Abdullahi M. Tanko versus Mohamed Kawu Modi. Citations are provided. The other notice of prior objection is the one filed by Chief Temple A. Amadi for the third defendant on the 28th of July 2023, seeking for the leave of this honorable court to invoke the provisions of Order 3, Rule 17, Sub 1 and 2 of the rules of this court and convert the originating summons to a complex and direct parties to file and exchange pleadings and to conduct the trial of the case in accordance with the rules of court governing trial. The notice of prior objection is predicated on the following grounds. 1, by virtue of Order 3, Rules 2 and 3 of the National Industrial Court of Nigeria Civil Procedural Rules 2017, civil proceedings may be commenced by way of originating summons in matters relating principally to interpretation of any constitution, enactment, agreements, or any other instrument relating to employment, labor, and industrial relations, in respect of which the court has jurisdiction by virtue of the provisions of Section 254C of the Constitution of the Federal Republic of Nigeria 1999 as amended, or by any act or law in force in Nigeria. 2, by virtue and under Order 3, Rule 16, Sub 1 thereof, any person claiming to be interested under an enactment, constitution, agreement, or any other written instrument may, by originating summons, apply to the court for the determination of any question of construction arising from the instrument and for a declaration of the rights of the person or persons interested, insofar as such question of construction arises from a subject matter over which the court has jurisdiction. 3, the instant suit raises substantial dispute of facts or is likely to involve substantial disputes of facts and therefore ought to have been commenced by complaint as provided under Rule 8 and 9 of Order 3 of the Civil Procedural Rules of this Honorable Court. In the written address filed in support of the objection, the learned counsel to the third defendant proposed these two issues for determination. 1, whether the originating summons and the statement of facts in support do not involve substantial disputes of facts or likelihood of substantial disputes of facts. And 2, whether this Honorable Court is entitled to convert the originating summons to a complaint and direct parties to file and exchange pleadings. It was submitted on the two issues which seem to have been argued together, that since from the totality of the questions calling for the court's answer, the reliefs/claims in the suit and the depositions of the claimants, there are substantial disputes of facts or its likelihood in the suit ought to have been commenced by way of complaint pursuant to Order 3, Rules 1 and 2 Sub 1, 317(1)(c) of the Rules of this Court 2017. That originating summons is the appropriate procedure to commence a suit where the facts are not in dispute, and or where the sole or principal question in issue is directed at the construction of a written law or other documents. The court was urged to grant a notice of pre-objection, to grant a notice of preliminary objection. References were made to the following cases: Ezeaku versus Okonkwo, Ezegwe versus Wadu, Keamo versus House of Assembly, Lagos State and others, Osai versus Wakwa, and Ogbane versus Hussein. Citations are all provided. In opposition to the notice of preliminary objection of the third defendant, the claimants filed written reply address on the 15th of August 2023, wherein this single issue was identified for determination. That is, whether this suit, within the circumstances of questions/facts of law raised for interpretation/construction of the court, is properly commenced under the originating summons procedure. It was posited on the single issue that this suit is properly commenced pursuant to Order 3 of the Rules of this Court 2017, that the claims before the court clearly fall within the purview of Section 254C1 of the 1999 Constitution as amended. It was further argued that since the instance suit is for the interpretation of Section 54 of the Rivers State Local Government Law number 5 of 2018, with respect to the disciplinary powers of the defendants, there are no disputes of facts, and the suit was properly commenced by way of originating summons. The court was urged to refuse the application and assume jurisdiction in the matter. The cases of Government of Kano State versus Economic and Financial Crimes Commission, SUPRA, as well as Abdullahi M. Tanko versus Mohamed Kawu, SUPRA, were also referred to. I have seen from the records that the two objections filed by the first and second defendants, as well as the third defendant, are both predicated on the same ground, that the facts in this suit are such riotous or contentious that they cannot be resolved by way of an originating summons or affidavit evidence without other evidence from the parties. The law is as rightly argued by both the learned SN for the first and second defendants and the learned counsel for the third defendant, that originating summons procedure is principally for matters relating to the interpretation of any constitution, enactment, agreement, or any other instrument, and where there are no substantial disputes or issues of facts. See Order 3, Rules 3 and 17 of the Rules of this Court 2017. In the case of Yombe, Doka, and others versus Congo, Komi, citation is given. The Court of Appeal by Shaibu JCA held as follows on when originating summons is appropriate to commence an action at pages 6 to 7, paragraphs B to C of the report. And I quote, "The key issue is the propriety or otherwise of commencing the suit at the lower court by originating summons. Parties are admitted that for originating summons to be an inappropriate originating process, the dispute on fact must be substantial, affecting the live issue in the matter, where the dispute on the facts are peripheral, not material to the live issue. The action can be sustained by originating summons. This is so because there can hardly be a case without facts. It is facts that make a case, and dispute in facts that give rise to litigation. See Tanko versus Modi. By and large, substantial dispute imputes a real material dispute or controversy of considerable importance as opposed to an imaginary peripheral dispute. The question now is the dispute before the lower court substantial, which could only be resolved upon calling other evidence based on pleadings. In determining whether a suit brought by an originating summons raises substantial dispute of facts, it is the nature of the claim and facts deposed in the affidavit in support of the originating summons that is to be considered. Thus, mere filing of a counter affidavit to oppose the claims in an originating summons does not make the facts contentious and proceedings hostile in nature. Osai versus Wakwa, FGM versus Zebra Energy Limited, and Jimo versus Ashin Loye number 2, end of quote. I have looked at the facts deposed to in the affidavit in support of the instant originating summons deposed to by the first claimant on the 27th of June 2022, and seen that even though The main grounds of the claimants is the alleged withholding and deduction of their salaries by the first and second defendants. What they seek from the court is the interpretation of the laws submitted for interpretation with respect to the statutory powers of the first and second defendants to take any disciplinary action affecting their contracts without the involvement of the third defendant. It is obvious from the affidavit of the claimants that the facts are not really contentious as to require other evidence in the suit. Even if they are contentious, I hold a considered view that the facts are not such that cannot be resolved via affidavit evidence or originating summons. In the circumstance, the notice of prior objection of the first and second defendants is hereby refused and discountenanced. Same is accordingly dismissed. Having refused and dismissed the notice of prior objection of the first and second defendants, it is obvious that the same fate shall befall that of the third defendant, since the grounds of the objections are the same. There is therefore no need to consider the objection of the third defendant. I hold that the ruling/decision in respect of the notice of prior objection of the first and second defendants shall abide or apply to that of the third defendant. The objection of the third defendant also fails, and same is accordingly dismissed. The court hereby assumes jurisdiction in the matter, whether or not the facts in support of the original summons are strong and cogent enough to support the claims of the claimants is what shall be considered in the substantive suit. With respect to the substantive originating summons, I have seen that while the claimants submitted 5 questions for the determination of the court and also 6 from the court, 7 main reliefs arising from the interpretation of section 7 sub 5 of the first schedule to the 1999 Constitution as amended, and sections 44 sub 1, 48 1 and 2, 54 sub 1 and 2b of the Rivers State Local Government Law number 5 of 2018, in the merely 2-page written address purportedly meant to support the 5 questions, the claimants only refer to section 48 and 54 1 and 2b of the Rivers State Local Government Law number 5 of 2018, which was reproduced. There was no effort to link the laws with their case and show how the defendants violated the said laws vis-a-vis the statutory powers of the defendants. Nothing was said about sections 31, 32, 33, 34, 35, 36, 37, and 38 of the Rivers State Local Government Law, as well as section 7 sub 5 of the first schedule to the 1999 Constitution as amended, which were submitted for interpretation. The point being made is that while section 36 sub 1 of the 1999 Constitution as amended, with respect to the right to fair hearing, relied upon and reproduced by the learned counsel to the claimants in their written address, is germane to every proceeding. The said provision being the general requirement of the law, the claimants have the burden of showing the court how the defendants breach their right to fair hearing. They must link the said constitutional provision to the right to fair hearing allegedly violated or breached by the defendants. The claimants merely file a 2-page written address in respect of 5 questions they submitted for determination. Should it then be the duty of the court to go on fishing expedition and make up a case for the claimants? That is clearly not the duty of the court. See the case of Mr. Clement, Ebeachu, and others versus Chief Linus, Ozogu, and others. Citation is given where the Court of Appeal held as follows, and I quote, "However, I have to say that pleading or citing a case of law and or disclosing intention to rely on same is not enough, as the person pleading it must lead evidence on the pleading, and the address of counsel must illustrate or demonstrate the relevance of the case or law to his evidence to assist the court in appreciating the case or law and applying it to the case at hand. Otherwise, mere mentioning or pleading of the case or law will amount to dumping same on the court and saddling the court with the burden of scouting for the case or law and reading same to see how same can apply to the case. In my view, that would amount to dumping of documents or evidence on court and sending the court to go on a search and scouting for materials to aid a party in his case. This cannot be allowed. See also the case of David Itauma versus Friday Jackson, where the Apex Court admonished judges in the following words: "It is not within the competence of a judge to make a case for the parties." End of quote. It is unbelievable that the claimants who annexed about 107 documents or exhibits to the affidavit in support of the urgent summons, who filed only a 2-page written address, and none of the 107 exhibits was referred to in the written address with a view to linking them to the provisions of the laws submitted for interpretation by the court, which were allegedly breached by the defendants. This court cannot go on an errand for the claimants to begin to sift through the documents and link them to the claimant's case and the laws in question. It was only in the further written address filed on the 27th of June 2022 that they merely listed the bank account statements and no more. I must add that I have also considered the provisions of section 48 and 54 of the Rivers State Local Government Law number 5 of 2018, which were reproduced by the Claimants Council relating to the powers of the third defendant. I have not seen where the claimants allege that the third defendant violated those powers. They also failed to link the said provisions to the first and second defendants by showing how the first and second defendants usurped the powers of the third defendant. The point must also be made that the claimants' reliefs A to D, which are the principal reliefs in the suit, are in the nature of declaratory reliefs. This imposes a severe burden on them to produce credible evidence without relying on the evidence of the defendants. The law is that declaratory reliefs are not granted, even on admission or default of pleadings by the defendants. In the case of Alhaji Shehu Yusuf versus Ben Chile Kiado and others, citation is given. The Court of Appeal by Ibrahim Ali and the Yaso JCA held as follows, and I quote, the main claim being the declaratory relief, the first respondent was bound to prove his case on the balance of probability and by preponderance of evidence. He has to do this by cogent, credible, and plausible evidence and must succeed on the strength of his case and not on the weakness of the adversary. See AG Rivers State versus AG Bayelsa State, Wadiku versus Okanu, Dantata versus Mohammed. In the case of Dape and another versus Musa and others, this court by Abiri JCA held as follows. The appellants sought before the tribunal declaratory reliefs. Declaratory reliefs are not granted as a matter of course and on a platter of gold. They are only granted when credible evidence has been laid by the person seeking the declaratory relief. A declaratory relief will be granted where the party seeking it is entitled to the relief in the fullest meaning of the word. The person seeking the declaratory relief must plead and prove the claim for declaratory relief without relying on the evidence called by the defendant. However, there is nothing wrong in the plaintiff taking advantage of any evidence adduced by the defense which tends to establish the plaintiff's claim. See Anyanru versus Mandilas Limited, Chukuma versus SPDC Nigeria Limited, Matami and others versus Dada and another, Ogwanuhu versus Chiaboka, Akimboni and others versus Akintope and others, and Mbodan versus Dabai. End of quote. See also the cases of Mr. Ebong John Ebong versus Mr. Okonwari Ebong and Davian Ondo versus Chief Ati Meba and another. Citations are also provided. I hold the considered view that the claimants have, I therefore hold the considered view that the claimants have by their self-infliction not established their case as required by law. In the final result, I hold that the claimants have failed to prove their case before the court. The questions submitted for interpretation and the two issues submitted for determination by the claimants are resolved against them. Let me add that even though I have not seen any merit in the case of the claimants, I have, however, considered the justice of the case and am of the considered view that the appropriate order to make in the circumstance is one striking out the suit rather than dismissing it. In the final result, this instance suit is hereby struck out. Judgment is entered accordingly, and I make no order as to cost.
Most grateful, my lords.
Thank you. Let us say.
My lord, we are grateful for the well-considered judgment.
Thank you.
And I just want to say that this is a wonderful way for the courts to proceed because it makes trial very, very simple. We're indeed very grateful as a team. And I'm speaking not only on behalf of the first and second defendant, but I'm sure for all counsel who appeared in this matter, we wish my Lord happy stay in Yenagoa. Most grateful, sir.
Thank you. Thank you. All right. That is the end. Have a nice day.
Thank you, my Lord.